All right, one of the things you want to plan for if you're not married is to make sure that you have an estate plan that addresses you and your long time relationship, right? If you've been in a relationship for a long time, you've got somebody, you all aren't married. That could come with complications when either if something were to happen to either one of you, or then eventually when one of you passes away. Now, there are some laws, and each state is dependent on that, what will happen. But in most states, in the majority of states, regardless of the amount of time that you've lived together, if you all do not own the assets together, specifically titled joint tenants with right of survivorship, something like that, it's a situation where if your partner passes away, his or her share might not automatically go to you. And we see this all the time. So you can imagine a piece of real estate, if it just says a single person and a single person, and it doesn't have the language, they own it as what's called tenants in common, even if they've owned the property together for 30, 40, 50 years, when one of the partners passes away, his or her share may not automatically go to the surviving partner. It might go to the next of kin, to their family members, which may or may not, give it to the surviving partner. They may not get along, creates a whole issues of problems. So when you're doing your estate plan, you definitely want to make sure that the assets are titled in a certain way so that they'll go to the other person, that they're retitled into the name of the trust, or that the assets themselves, if you don't have any estate planning and you have a longtime partner, look at how you own those accounts, right? If you have a checking account, is it jointly owned, meaning that when you pass away, your surviving partner can still have access to it? Did you list him or her as a beneficiary on those accounts if they're not a joint owner? Same with real estate. You want to take a look at that as well and see how you own that. So that's a big issue. Second is the big issue of being, who gets what of your stuff, and you want to make sure that it continues to go to your partner. But the second issue is why you're still alive. That might have to do with medical things. If you're in an accident or you get Alzheimer's, dementia, something like that, who you want to take care of you. If you don't have those necessary documents in place, like a power of attorney, like a healthcare surrogate, like a living will, that type of stuff, then it might not be your partner who's going to be able to step in. They're not your spouse. You're not married. In the court, the doctor's office, the court, if you need to go do a guardianship, may not give preference to that person. They may name somebody else. So again, there's a whole, it's not necessarily complicated, but there are the outcome of what could happen without doing any sort of planning can be very drastic for unmarried couples. Whereas, if you're married, typically, even if you don't have an estate plan in place, the laws are such that they're going to go to your next of kin. So that works if you're married, but if you're not married, it's not going to go to your partner because you're not married, and obviously it's not next of kin. So something to think about when you're doing your estate plan as an unmarried couple.